We continue to read the case of Roy Dessado versus Jennifer Brown. Overriding objective in dealing with cases justly. To borrow the words of Lindo J. in Gavin versus Gavin, paragraph 17, it is well settled that there were issues of limitation arise, and these are debatable. It is inappropriate or undesirable to attempt to decide them on interlocutory applications except in the clearest of cases. In determining the parties' entitlement under the Property Rights of Spouses Act, it is for the trial judge, after examining the basis of the claim, to determine the respective interests of the parties. Alright? It is the trial judge who will determine your interest. By the way, remember, if you're not subscribe to this channel yet, please do so, and like, comment and share this video, and check out the links that I've put in the description of the video below. Alright, we continue. Therefore, in considering the overriding objective in dealing with cases justly, I refer to Section 6 and 7 of the Property Rights of Spouses Act, which combined operates to allow for a claim in interest of the property at the end of cohabitation, and for the court to determine such such interest in such event. It must be stated that the factors to be taken into account in determining a party's interest listed under subsection 7 part 1 are not, section 7 subsection 1 are not intended to be exclusive or exhaustive. So this section gives some examples of reasons why this extension might be justified, but there could be other reasons. The claimant, as Mr. Dessado and Ms. Brown, say that they have paid the mortgage and upkeep of the family home. However, neither party had brought evidence in support of such assertions. So you see, when you buy a bag of cement, length of steel, paint, whatever it is, take pictures of the receipt and save them, because you might need to present them in court. Whether you are married or living in a common law union, you might be called upon to present those receipts in court one day. Right? They did not bring evidence to support such assertions. The defendant in these circumstances, as Ms. Brown here, in these circumstances, therefore, has a case to respond to by virtue of the legal and equitable interest alleged and the relevant statutory provisions. At this stage, it is yet to be determined whether the claimant did indeed intend to abandon his interest. Let's look now at the orders given by the court. I therefore, in all the circumstances outlined above, make the following orders. 1. The claimant, Mr. Dessado, is granted an extension of time to make an application under the Property Rights of Spouses Act. So even after 18 years, he was granted that extension of time. But as you see, it is because his name was on the title, and they both agreed that they paid the mortgage for that property before he left it. Alright? 2. The fixed date claim form and affidavit in support filed are to stand as filed. 3. Affidavits filed on behalf of the defendant are to stand as filed. So remember, the affidavit is a document which you sign, sworn statement, and can be used in court. Trial is set for November 28, 29, and 30 of 2002 before a judge in chambers. We look forward to that. It's not yet that time, but we will look at it if it is published. The respondent is to file affidavit in response on or before July 29, 2022. The claimant is permitted file a response, if necessary, on or before September 2nd, 2022. No further affidavit to be signed after September 30th, 2022. Core bundle and index to be filed on or before November 11, 2022. Costs in the claim, applicant and claimant's attorney to prepare, file, and serve orders. Hearing. So, that is the case of Roy Dessado versus Jennifer Brown, where Roy Dessado is applying for a share in the family property after 18 years leaving the property and Miss Brown living in it undisturbed. He was granted an extension of time beyond the 12 months that is required in the Property Rights of Spouses Act.